you, Chair Wagner, members of the committee. Good afternoon. For your record, my name is Sara Gelser. I'm the state senator from Senate District 8. Senate Bill 489 comes to you after several years of conversations about the idea of cyberbullying and the increasing impact of social media on our schools. And it came particularly out of a discussion about a situation that happened within my legislative district at Corvallis High School. You have in the record written testimony from Mr. Matt Boring, the principal, who was unable to attend because of a schedule change due to a snow day yesterday. And we also have a mother of an impacted student. But briefly, this was a situation where there was some pretty significant allegations of online sharing of inappropriate photos of a student without her consent that led to a very significantly hostile learning environment for her at school, to the extent that she couldn't go to school anymore. The social media organization had saved the information about the IP address, the actual photographs, the content of this website that was used to bully this girl, allegedly. And law enforcement looked into it, did not move forward with criminal charges, and determined that it was really up to the school to manage this as an inter-student issue. However, the principal, under state and federal law, is not a party that is eligible to access that information from the social media company that I believe is only stored for 45 days. They can only get that through a subpoena issued through law enforcement or a district attorney, and they were not able to secure that before the end of the 45 days. This meant that the principal was actually not able to issue any discipline because there was no evidence that the event had actually occurred. So working with the Legislative Council, we tried to figure out how to draft this bill, and it is still a work in process. Initially, the hope was to be able to add a school administrator or a behavior specialist to the list of individuals that can receive this information. Solely for disciplinary purposes, it would be held very confidentially. It would not be able to be used for criminal prosecution purposes, but just for educational and school safety purposes. There were some issues with that. So where we ended up at the end of the drafting period with a lot of conversations with Legislative Council was to ask school districts and law enforcement agencies to collaborate together about how this information might be shared, even when there is not going to be a criminal prosecution. Ideally, in these cases, we would be able to intervene to be able to provide education and discipline to individuals who violate these standards, and not at the same time maybe set them up for a Measure 11 crime, but to empower school principals. Ultimately, we ask our schools to enforce cyberbullying rules and to keep kids safe from cyberbullying, but we give them no tools to do so. And this is the first step of that conversation. And I will turn it over to